page 499. So for the past 2 weeks, we've been opening these sessions with this text from the commendation. And there are moments where we do the burial rite, and we get to this part of the service, which is at the end of the burial rite. And the congregation, you can tell when the congregation knows these words. You can feel the sort of palpable relief and the defiance that are there. So I'm just gonna sort of keep coming back to it as we gather this week and next week for one more time. Join in with me. Give rest, O Christ, to your servants with your saints, where sorrow and pain are no more, neither sighing, but life everlasting. You only are immortal, the creator and maker of mankind, and we are mortal, formed of the earth, and to earth shall we return. For so did you ordain when you created me, saying, you are dust, and to dust you shall return. All of us go down to the dust, yet even at the grave we make our song. Alleluia, alleluia, alleluia. Give rest, O Christ, to your servants with your saints, where sorrow and pain are no more, neither sighing, but life everlasting. I'm grateful tonight to welcome Chris Kradle, who comes to us from Mazer, Amundsen, and Boggio, a firm that specializes in elder law. I have now said all the words I know about what elder law is, and that's exactly why Chris is here with us. You should have a handout with our logo, and you should have one of those blue folders. That's material he's going to be sharing with us. And please just pardon us for a moment. We're doing a little bit of tech support over here. I'm going to be the Vanna White, and if I am doing badly, please just be nice to me. Can we trust your microphone?
Susan, can you buy vowels?
Now, I'm coming in on this on week 3. I know you guys have been doing some things before this. Can you guys kind of fill me in? I've gotten a little bit here, but can you kind of tell me what we've talked about over the last 2 weeks? I'll try to see if I can make some things at least interlock so I'm not just doing a brand new one. Oh, there's the quiz. I'm the quiz? I didn't get my teaching license. Okay. But seriously, what did we do in week 1? Anyone? I'm going to call on people. I'm also going to let you know, this is going to have true or false questions, and I will call on people. I'm not afraid to do that, so you better know, or someone better speak up. Was anyone here a gunner? And so for you who are being here tonight and wanting to learn, I appreciate that, because these are topics that, to be honest, are uncomfortable, or you maybe never talked about until, after mom or dad passed away, and you go, now I want to be more prepared because I was left in a bit of a vulnerable situation, and I don't want to do that to my kids or who's ever going to take care of me afterwards. So what we're going to go through today is truly just going through the documents you need to know about. So when you walk away, you can say, hey, I remember this attorney saying these are the things I need to at least know about. And there are going to be some things where you go, yes, that's exactly what I need. And then other times you're going to say, no, that doesn't fit me based on what we talked about. And of course, I always say, go talk with an attorney. I'm here. I mean, you can talk with me tonight if you want. But if you have someone that you also trust, you can also just be more educated when you walk into the room and not feel like a lawyer's just blathering legalese at you. Hopefully we can get it in just English tonight. So I'll tell you a little bit about me. I've been at Mazer for, honestly, just a few months. I joined in December, but the reason why I joined is this is a firm that I really appreciate. We are a firm that actually cares about everything from beginning to end. We aren't just lawyers. We have a social worker on staff who helps people if they're trying to find long-term placement, or what are some of the community things that you would need. We have people come in with different levels of diagnoses, and they come to us and all of a sudden they leave and they go, not only do I feel like I'm set up for the future, but now I've got a plan in place and I can keep coming back to this firm. So a lot of times you'll see estate planning firms where it's a project-based. See you later, we might send you a letter in 3 years, but we like to think that if you need us, you can always reach out to us. I am a Minnesota and Wisconsin barred attorney, so I can help you guys with both. if in case anyone's got their fancy Wisconsin cabin. We don't have to talk about that tonight, but I'm very jealous of you. So what we're going to do, hopefully by the end of this, is we're going to make sure we can identify the essential estate planning documents. We're going to talk about the similarities and differences and how these documents affect you during life and at death. Now, this is the only thing I read verbatim. Estate planning is making arrangements in advance that name people to oversee the transfer of your assets upon your death. They will also make decisions for you while you are alive, but not able to meaningfully communicate choices. So the biggest thing I think you should look at first are, what are your goals? Why is it that you want to come do estate planning? Now, I'm not going to read through all these, but I want to highlight a couple that I think are extremely important. Clarity of beneficiaries. Now, if something were to happen to you tomorrow and you have children or grandchildren, I'm sure you want it to go to them. But if you don't identify the amount, who gets it, you can also say when they get it. They don't have to get it right away. If people are bad with money, that happens, where you go, I'd like that to hold off until you're 35. Otherwise, everything goes according to Minnesota law. There's Minnesota statutes that are out there. It's called intestacy, and it just basically goes, we've got your family tree, and it goes down this. The other thing with clarity of beneficiaries, especially since I'm here, you have to name anyone who's going to be a charitable beneficiary. So if you want to give to St. Luke's, St. James, you have to write that down explicitly. Minimizing estate tax consequences. Everyone gets worried about the tax word, and I understand why. But in the state of Minnesota, in 2023, if you have more than $3 million in assets, then you have to start doing estate planning. Luckily, there's not a lot of people that have that, but if that's a number that's kind of in your mind, you have to do some tax planning as well. Otherwise, you have the big state of Minnesota who's going to come and give you a tax. Federal level this year is $12.92 million. So if you have that, you needed to talk to me yesterday. And also, again, I'm very jealous of you. The other thing, not everything's a nuclear family anymore. We have a lot of people who come to us with blended families, second marriages, kids from both sides. And people say, we bought this house together, but I have my assets, my spouse has their assets. We want to make sure it gets down separately, but we've created this wonderful house together, and I want to make sure that maybe if I pass away, new spouse doesn't get everything. I want to make sure everything goes equally. You have to plan it out that way. Otherwise, it's going to be going under the Minnesota laws. And I know this is a terrible thing, but I want to tackle this right away, is disinheritance. I talked about earlier where there may be a situation where people aren't good with money, but now I'm going to take that one step further. We have dealt quite a bit with families who have addicts that would receive money. And I had a woman who came to me, and she was just extremely sad because she goes, if I gave everything to my child right now, he'd kill himself. And after we were able to talk through a couple things, we said, you know what? Of course your child should receive some money, but maybe we have to set it off to the side. Maybe the child doesn't get it right away. Maybe we have to prove sobriety. Maybe it's held in a trust for the rest of their life, and they get money only when they're good and ready for it. So otherwise, I think disinheritance is an extremely powerful tool, but sometimes it's a necessary tool. So don't feel bad if you go, you know what? I don't think this person really needs this. All right, I told you there was going to be a pop quiz. True or false, having a will avoids probate? We're educated. I like this. You guys have talked to your lawyers already? Did we already do this? You're absolutely right. So what a will does is it helps everything go through probate much easier. What you're able to do is a judge will accept the will, and there's two different types of probate. There's something called formal and informal probate. Informal probate means it turns into a bunch of paperwork. You don't even have to go in front of a judge. It's a bunch of filings that everyone okays at the end of the day, whereas formal means there has to be judicial oversight. The judge is going to sign off on everything. You're going to have to go in front of the judge. Every will should say that my wish is for it to be an informal probate. So, what is it with a will that you need to have? Well, you need to have these three things. It's got to be in writing. and it has to be printed. Sorry, if you hand wrote it at home, we don't do that in the state. You can do that in Wisconsin, you can't do that here. You need to make sure that you had intent, and it has to be signed or acknowledged before 2 witnesses. So what is it that you're doing about a will that makes it where you go, okay, I really need that? You're naming a personal representative. Now, you might have also heard this as executor. I use those terms interchangeably. That's the person who's going to make sure your wishes on your will, or even if you don't have a will, gets to the right people. And you get to name that trustworthy person, and it's got to be a person you trust. They are supposed to follow everything that it says in the will, but you can always have a rogue agent. So you got to make sure that's a person that you trust that's also going to get the job done. Again, the other thing that we talked about a little bit earlier with the person who had an addict child, we created something in a will. You can create a trust in a will. So it doesn't have to be within a trust itself, but it can also be basically a will with a trust. And that's what we did. We made sure we held on to all the property that was for that child in that trust for the remainder of that person's life, with only distributions as the person who we really trusted, the personal representative, and then that same person was also named as trustee. We'll get to that term in just a little second. That person was the one who was making sure that that person was getting the appropriate distributions at the appropriate time. So what are some unintended consequences of you not having a will? This doesn't plan for disability. Now, this is something that you may not have thought of, and if you are, you consider yourself one of the lucky ones. We have people who come with our clients that have disabilities, and they are getting government benefits. And in order for them to continue with their government benefits, they cannot have an income above a certain amount or assets above a certain amount. So if you are making, if everything goes according to Minnesota law, they get it outright, which might mess with their government benefits. So we got to make sure we plan ahead for anyone who has disabilities. And this is the other one, is pits family members against each other. And I cannot tell you how the smallest little things grow into the biggest. And I'll give an example. One client had 6 kids, 13 grandkids, good Catholic family. And we go into grandma's house after grandma passes away, and all the grandkids are just going through and just getting little trinkets. Nothing special, nothing big, bad, or ugly. But lo and behold, all 13 grandkids wanted this one wood doll. I don't know what it was about this. I can't explain what it was. I think they all played with it. And for some reason, there was a bit of a kerfuffle. There was some yelling. There was some arguing about it, about this wood toy that you never would have thought of. Now, I'm not saying that you can plan for every little thing, because who would have thought that after grandma passed away, this one wood toy would have caused a kerfuffle. But sure enough, that was something where apparently there were some hurt feelings afterwards. Again, you can't plan for everything, but just a weird one-off thing that I can think of. All right, we're back to the quiz. According to Susie Orman, everyone needs a living revocable trust. Is that true or false? I would say false. Not everyone needs it. There are definitely times where having a will is going to be better for you in actually the long run. So with trusts, you can read through, again, the boring legal bullet points, but we have a legal arrangement where assets are held for a third property, and I like to think of it as a bucket. That's the vehicle that everything's held within. But it is you, and you are the trust. There's no different tax ID. You're still using your social security number. And so everything, all your assets are going to get transferred into the trust. You have a trustee who manages the assets. Now, most of the time, that's you. Now, if something happens, though, when you plan ahead, you're going to write in the trust, what happens if I'm incapacitated? What if I'm in a coma? Someone needs to take over because this vehicle is just hanging out there with no driver. That scares me. So that's why you always make sure you have a backup. And just like you would in a will, you're going to name the beneficiaries who are going to get everything. Again, I really think trusts are helpful when you're planning for incapacity. Again, what happens if you've got $500,000 in your very nice brokerage account, and lo and behold, the stock market crash happens again? Well, we got to make sure we pull those assets out. The person who's a trustee, even if it's not you, if we've named someone else, they have a duty to make sure your assets are maximized. They're not doing it for their own benefit. They are doing it only for you. Again, you got to make sure you have a trustworthy person, but you know those people. I hope you know those people. The other thing is you foster easy transition of property from the trust to the beneficiaries. Unlike with a will, where we talked about before, you don't avoid probate. This means if someone passes away, the next, and they were the trustee, they were the person who created the trust, after that person passed away, then everything could truly be distributed that very next day. So there's no waiting period as well. A lot of people like it for that purpose. All right, so if I have a trust, I don't need a will. Is that true or false? Okay, you guys really got the answers ahead of time. I appreciate this. So you stole? Yeah, you gave it to everyone. All right. What happens when you have a trust is you are also given something that's called a pour-over will. That's a safety net. I like to think you won the lottery, you opened up a brand new bank account because you weren't going to tell anyone about it, but it didn't make it into your trust. What a pour-over will, and it's spelled P-O-U-R, is whoopsie, we weren't supposed to be here, everything goes to the trust. It's a very simple will, but it's something that you will also have with a trust. So what are some of the big differences between the two? I point at that it crosses state lines as the first and foremost because I'm a Minnesota and Wisconsin attorney. So if you had a property in Minnesota and a property in Wisconsin and you didn't have them in one trust, you would wind up having two probates. Worst case scenario, because that's just going to eat up attorney's fees, and who wants to pay attorneys any more than they absolutely have to? The other thing is you can plan for special needs. You can plan for your pets. You can plan for remarriage, again, making sure that the money doesn't go to a second spouse. And you can do creditor protection. And I also think of creditor protection as the same thing as the person with an addiction, making sure that they are protected and the money that they so rightfully deserve is also protected. So now we've talked about this scary thing called probate. So what is probate? I talked about before, it is a court proceeding, and we talked about informal versus formal, but it is a public thing. You have to notice, you have to let creditors know because probate's the last time anyone can make a claim against it. And you have to make sure you inventory everything gets reported to the court. But this is where people get really scared of these last two bullet points. Lengthy. The truly shortest amount of time from beginning to end is 5 months. And the reason why it's 5 months is during that creditor period, creditors have 4 months to write because they want to give them every last shot. And the other thing is it can be costly. If things get a little haywire, again, things just add up and turns into more attorney's fees. All right, now we're getting to a couple case studies. I think we all know about Prince. So there's a little bit that you might not know about, and I just want to share a couple things with you that are interesting to me from a legal world. His estate was worth $156 million. I know. That's exactly right. What happened is there were, I believe, over 50 people that said they were related to Prince. Wind up being 6 half-siblings at the end of the day. But what happened was we had to go through all of those 50, and we had to make sure those people were who they were. A lot of them weren't. And then, during this entire time, they were trying to figure out with the IRS how to value his discography. It's pretty subjective in the grand scheme of things, but the valuations were so different, they had to go back and forth before the IRS said yes. Prince's discography was worth, I believe it was about $130 million. That's what they decided on. But during this entire thing, one of the half-siblings passed away, so they didn't receive a share. And I don't know the attorney's fees, but I went online and I went through the last 2 filings because there was a bunch of recorded, basically they had to provide monthly accounting. And I can tell you conservatively, out of that estate of $156 million, well over $10 million was spent on attorney's fees because of the bickering. The last month was $1 million, and I'll tell you that was probably one of the slower months because a lot of work is done at the beginning of probates. So we talked about those two, and those are things that affect you after you passed away. Now, you have to plan for it while you're alive. But now we're going to talk about things that affect you here and now while we're on Earth. First is a healthcare directive. Has anyone heard of this, or has anyone signed it? Actually, show of hands, people who've... Okay, We've got well over half. Okay, so we know what a healthcare directive is. But the reason why you do that is you're, again, ahead of time planning on who's going to make healthcare decisions if you're incapacitated. And this is only if you're incapacitated. Otherwise, you have to go through guardianship. And that is a court procedure where we have to identify who's the trustworthy person, who's going to do on your best behalf. Again, unnecessary court fees, because if you have a healthcare directive, you've already identified people who are going to take care of it. And the other thing, these are things, if you do this, if you go through these four, especially organ donation, burial, cremation, heroic measures, you are actually going to make the world so much easier for who's ever going to make those decisions on your behalf. All of a sudden, it's in black and white. What is it? Did mom want to be hooked up to tubes? No. She wanted to pass peacefully. Did she want heroic measures to be taken? Yes. She wanted to be around because she really wanted to see her grandchildren grow. All of a sudden, the ifs, the whys, they get answered. I think this is one of the greatest gifts that you can give. It's giving what you want ahead of time. And to be honest with you, even though you sign this, communicate. Talk with the people who are assigned. So in case something happens, they're not looking at the healthcare director for the first time. All of a sudden, they know what your wishes are. All right, true or false, I don't need to write down my wishes for the end-of-life care. My family knows what I want. Okay, good. Oh, gosh. No. All right, Casey Kasem, the voice of the 70s. Anyone remember what happened to Casey? Because it might be a little crazier than you actually remember. Okay. Chaos is the right word. That's exactly correct. So, Casey is married to his second wife. He was diagnosed with Parkinson's disease in 2007 and is put in a home. And I'm sorry, I have to read this because I don't remember every single step of this. Second wife prevents the children from the first marriage from even visiting Casey. Already a red flag right there. The kids are trying to file so they can see dad, and they're filing for something called a conservatorship, which means not only are we going to take care of dad in terms of his health, we're going to take care of his finances. And conservatorship in California is different than conservatorship in Minnesota. I just want to let you know. So it takes them 2 tries. So again, unnecessary attorney's fees, just so they can see dad. During this time, second wife moves Casey from California to Washington State. It is unknown why. During this time, he's getting an ill health, and the judge orders Casey to be fed, hydrated, medicated. But then, finally, we find something that was written in his handwriting that says Casey did not want that. So the judge allows Casey to have end-of-life measures, make him comfortable. So he dies in Gig Harbor, Washington. Now, obviously, he's been in Hollywood his entire life. And his cause of death, officially, was sepsis caused by a lacerated bed sore. Just painful. Exactly. He has in his wishes that he wants to be buried in Glendale, California. I think that's where he raised his family. It's where he has all his good memories. So this is where I'm willing to bet, I'm sorry, I know we're in church, but I'm willing to bet $20. Where is Casey Kasem buried? Gig Harbor, Washington is where he died. That's a unique one. I haven't heard that one. He was interred. Mm-hmm. Oslo, Norway? You can go visit him in Oslo, Norway, according to his second wife's wishes. This is Jean. Was this Jean? It was Jean. Yes, she was an actress. Yes. So, and yes. Also during this time, it is unclear. He wound up in Canada for a little while. Don't know how or when that happened, but we know he was in Montreal for a little bit too. I believe that was actually while he was still alive, to be honest with you. We could have written this down and figured all this out ahead of time. This is literally the worst case scenario. This is something that we still study. After Terry Schiavo, I don't know if you remember her, she was a very controversial figure in the 90s. This has become what I would consider the contemporary Terry Schiavo, what you don't do. So now we're going to talk about the power of attorney. Now, we talked about the healthcare directive. That's who's going to make decisions for you while you're alive but incapacitated about your healthcare decision. This is going to be who takes care of your financial decisions. We've got two different types. We've got a short form, and when it says statutory, it means we literally ripped it from Minnesota statutes, and common law. So this is going to make sure that you can gift. This is if for some reason you become incapacitated, that someone can step in. We call it making it durable. That is going to continue on even if you're incapacitated. But you have to choose your agents carefully. I would argue this is the most powerful estate planning document you will sign. In the state of Minnesota, if you sign the statutory short form powers of attorney, and then the person who is named, sometimes, most of the times it's a spouse, sometimes they have other people who they trust, the moment that that person signs, they can act under the power of attorney. There's no waiting. So when you hear the stories about a celebrity or an athlete where all of a sudden their bank account was wiped out, there's two different ways that happen. One, they were named jointly on that bank account, just like you would with a spouse, or they used a power of attorney and they wiped the bank account out. Now, of course, it's fraudulent. They have to be acting in a fiduciary capacity. They have to be acting for their benefit, but that is the bad actor issue. So in Minnesota, we talked about guardianship. That's who would make your healthcare decisions, but we split it up in the state, unlike California. Conservatorship is who would take care of your finances. Again, it's the same exact thing. You're going to court, that's unnecessary. You're going through a proceeding that is completely avoidable. All right, true or false? A power of attorney is effective even before a signer becomes incapacitated or incompetent. I just need someone to say that they were hearing me what I said last time. Okay, good. This is me waking everyone up. Good. All right, who has heard about a transfer on death deed? Okay, good. Oh, even better. I like this. Transfer on death deed is what I would consider you're putting a beneficiary designation on your house. So you've got beneficiary designations hopefully on your IRAs, but this is something you file with the county recorder's office, and what it does is it allows the property to avoid probate. And what happens is if you pass away, and say it's you and your spouse because you owned it jointly, once the last of you passes away, then it will go to the people that you've named in that transfer on death deed. But say you don't want to live in this. This is not your forever home. You can still sell it, and basically everything gets overwritten. It's like it was never there in the first place. So it's really not a terrible thing, and you can revoke it. If all of a sudden you go, actually, I only want it to go to one child instead of two. You have that option too. It's not a forever thing once it gets filed. But the one thing I do want to let you know is unintended beneficiaries. Sometimes people go, I really want to make sure it goes to my son, and if my son isn't alive, then it's going to go to his children. Now, his children are minors, and we'll say, unfortunately, son passes away before you, and now it's supposed to go to these minors. Everything gets held up. There's got to be someone who's appointed that's overseeing it, and while you're trying to do the best for those minor children, it could be a pain in the butt. The other thing I ask, and I know this isn't very kind, but do you trust your in-laws? Do you trust who your children married? And it's not that they would receive a single dime out of all this, because obviously they're not the owners, but they do have to sign off on the deed. All spouses have to sign off saying, I agree that this is going to pass on to these new buyers. Sometimes when I say that, they go, yeah, John's going to be a pain. I don't want to do that. So, and it's okay. But this is just a tool for you guys to know about. It doesn't work perfectly, but it is one of the things that we're still learning about, because obviously we've only had it since 2008. Now, I want to give you a little bit of good news. You've probably done this in estate planning. Beneficiary designations. Anything with a beneficiary designation or anything that's held jointly doesn't go through probate. So all your life insurance, all your IRAs, making sure that everything is done correctly. So this is your homework. More homework, I'm sorry. Go and check your beneficiary designations. Make sure everything's up to date. Make sure it's in the percentages that you want it to be. And the only reason why is I had a client who came in, I know TCF got bought out by Huntington recently. Went into Huntington and went through their beneficiaries and everything had been wiped out. So luckily she caught it ahead of time and we were able to redo everything. It's not a bad thing to check, and double check, just because electronics can be funky and they can be weird. So here's a really good question. The beneficiary of a life insurance policy that you named must use the proceeds to pay for the funeral. True or false? Correct. Someone tried getting around this by saying, but what if I had a contract? I had a contract with an individual. Have to use it only for my funeral. No. You can't even get around it that way. When they receive the assets outright. They can do with it what they wish. And even if you've communicated with them, this is the purpose of it, doesn't necessarily mean they're going to act the way that you want them to act. So again, yes? If it goes into a trust, then yes, you're going to hold on to it that way. But then that creates a little bit of an issue of it goes into the trust, and is it going to go equally amongst the kids then, instead of being used specifically for the funeral? So in wills and in trusts, one of the provisions we say is we want to make sure we pay off everything. And one of the first creditors, according to Minnesota statutes, is anything that's funeral expense. We want to make sure your funeral is paid for. But at the same time, if that's the only thing that's there, then the kids aren't getting anything at the end of the day too, and you've kind of messed them with all their money that they were supposed to get otherwise. It's a fine balance, and I'll be honest, that's a case-by-case basis. Sometimes that does work. So when to update your estate plan? Again, I know I said I don't read too much verbatim, but there's a couple things I really want to focus on. If you have anything, I know we talked about very large numbers, but if you have anything that would come close to the estate tax, very, very important. If you have anyone in your family with special needs, especially if they're receiving government benefits, if you have property in more than one state, I know we're in a state of snowbirds. We have a lot of people that are in Florida or Arizona. Let's make sure that that's taken care of as well. Did you get recently married or divorced? I want to also add this. It's birth, death, marriage, and divorce. Those are the main things where people all of a sudden think, I got to change things up. Those are the big 4 life events. And I'll tell you one of the reasons why I'm thinking about this. I have my estate plan, but in June, I'm due with my first. I know I got to get everything changed because everything's obsolete. Everything's out of date the moment that kid comes into my life. The other thing, will your family members agree on your end-of-life care? Again, think of Casey Kasem. What would happen if everything would have been put in place? We wouldn't have had anywhere near that kerfuffle. Do you have your retirement plan and estate plan coordinated? You may have your IRA where it's going, 100% to spouse, 50% to children. But when we set up your estate plan, your will or your trust, you actually have the child not receiving everything until they're 40 because they're just not good with money right now. You think it should be held in trust. So right now, you would be giving them the ability to get that IRA money out, but that's not what your estate plan wants. So you got to make sure that's lined up as well. And the other thing is a diagnosis that may require long-term care. Getting ahead of that in terms of doing planning for long-term care, making sure that you have assets to make sure that you last, or if you're trying to do some gifting where it gets to the end and you need to get on those government benefits that you so rightly deserve. So at this point in time, I don't know how much time I have left, but I will take any questions or answers that we have right now. Yes? So the question is, if I have a daughter and I don't want to I want to disinherit her, I don't want her to receive anything, do I have to include her in my will, or do I have to give something to her in my will? Some people feel that they should give $1 or just a nominal amount that goes, I thought of you. I personally think that the best way to handle that is omitting that person entirely and including in your estate plan document, the reason why I am omitting you is because of X. I have thought of this for a good long while. And you can also include something in the will that is called a contest provision that goes, if you contest the will, there's no way you can receive anything from it. Contest clauses are still a little bit new and are still being figured out in Minnesota, but people feel much better if they go, you really can't contest this, and I know you're already receiving nothing, but on top of that, we're going to make sure you won't even be able to get any attorney's fees out of it as well. So that is my personal philosophy, is I think omitting someone entirely is better than even giving a nominal amount, because you know your family much better than I do. There might be a reason behind that, whether it's drugs, whether it's just an irresponsible human being, or maybe it's someone who's just been what I would call a financial drain upon you. You've already given enough to that person as well. And it wouldn't be fair for that person to receive any more assets outright. I defer to what the clients have to say, because you know your family better than me, but in your situation, I would say omitting entirely would be the right avenue. Yes?
Is moving to another state a reason to change your will? Or just, like birth, death, marriage, divorce, is moving to another state a reason?
So the question is moving to another state a reason to change your estate plan? And I say yes. Whenever we have clients, we lose a lot of clients to Florida. I don't blame them, especially in winter. But we tell them to immediately reach out to an estate planning attorney in Florida. Some of it may transfer, but every state has different laws. There is, I don't want to bore you too much, but there are lawyers much smarter than I that came up with things called the Uniform Probate Code, the Uniform Trust Code, and a lot of states have adopted that as their base. Now, of course, they tweaked it a little bit, but even those little tweaks, because in a Florida trust, and I've seen one of these, they care about environmental impacts. That's actually one of the things that you have to think about as a fiduciary. In Minnesota, we don't have such a clause. So I would say at least visit, and worst comes to worst, if you visit with a Florida attorney, they will change the situs of the trust, where it would be administered, or where the trust or the will would be administered. So it would be under Minnesota law. Otherwise, that person would have to probate the will all the way back in Minnesota too, if residency was never established in the state that you moved to. So I would at least confer with them and just say, I have these estate planning documents from Minnesota. Please review them. Tell me if they're good and they only need a small tweak. Do I need brand new documents, or am I good to go? Question is, can you have a blanket contest clause? And the answer is yes. You can have no one contest this.
Creditors.
And no, they can't get away with that, unfortunately. But no, it's the people.
IRS.
Are you interested in joining that really smart group of lawyers who did the Uniform Probate Code? If you can get creditors off my back, I'd really appreciate that. But no, I would consider that it would be beneficiaries. It would be like, yeah, your third cousin showed up and really thought they deserved something from you. I don't know why, but they really thought that. So which option, a will or trust, is best in getting the maximum amount of money to the hands of the beneficiaries? And I might be paraphrasing, which one is less fuss? Would that be pretty fair? For the beneficiaries. I think in the grand scheme of things, you wind up paying basically ahead of time more with a trust. A trust is going to be more expensive. It also requires you making sure all the assets are put into the trust, so that there's no assets that would go through probate. But at the end of it, in terms of fuss, I really think a trust is the easiest way for the beneficiaries to get it from point A to point B. In terms of the maximum amount of assets, it really depends on case by case, but I personally lean again towards trusts. I think that would be the maximum amount of assets that, even though you are paying more ahead of time, you're not paying attorneys hourly fees for a probate. And an easy probate is still a couple grand. Yeah. Also true. Again, it's a little case by case, but I would say majority of the time, yes. Yes. Yes, so that's a really good point. In the state of Minnesota, $75,000 is the magic number. If you have probate assets that are less than $75,000, so we'll say it's one bank account. Say you put a transfer on death deed on your house, you've got 2 retirement accounts, those have beneficiary designations, you just forgot your savings, and your savings has $20,000 in it. You do not have to go through probate. You use something called an affidavit of collection. And the affidavit of collection is something that you would take to the bank. They have to accept it, but they freak out a lot because they think everything has to go through probate in the state. But the only thing that's a little scary about the affidavit of collection is anyone can get that as long as they are an heir. So it's not your personal representative. It's going to be child, grandchild. It could even be your mom and dad if they're still alive. But once they collect all that asset, the bank doesn't care about how it's distributed. So that $20,000 going to child one does not, under the will, would have to give $10,000 to child two. But there is nothing that forces that person besides being a good person to make sure child two gets that $10,000. There could wind up being litigation, but it's one of those things, why would you even litigate that? But that child also is hopefully receiving, the trust or the house from the Todd and other things, but there's still $10,000 that child didn't receive. So that's the only scary part about that. Just want to give you that heads up. Yes. So you're talking about the question is you are named either as a joint account holder or a payable on death beneficiary, where after your mom passes away, you have access to those assets. So having all that happen, I would say, works out very well if there is one child, if everything is going to one child. Otherwise, in order to equalize it, you would have to gift the assets to all the other people under the will. The other thing is, if you receive all the assets, there is no legal obligation for you to give, and I don't know how many siblings you had, but I'm going to make up you've got 2 others. Magically, congratulations. Those 2 siblings have no rights to anything that was held in that payable on death or jointly held. Everything goes to you and you alone. You do not have to distribute it according to the will. It turns into basically you, in a good faith effort, giving it to those people, your 2 other siblings. But in order for you to gift, we'll just say you get $200,000, everything from the payable on death. In Minnesota, according to the federal law this year, you can only gift $17,000 at a time to each individual. So tomorrow I can give you $17,000. It wouldn't create a taxable event. Anything over that, you have to file a gift tax return. So it might be a long, drawn-out process to make everyone whole, or you have to file a gift tax return that counts against your $12.92 million federal exemption, but it is also just an extra tax thing to handle. So, yes.
Chris, that's a lot louder than I thought it was. Chris, the baseline assumption we've been making here is that we have financial assets or just assets that we want to pass on in a particular way. And so I just want to name that that's a privileged point of view for us to be coming from, right? So we can have a lot of gratitude if that's a point of view that we're coming from in this room, mindful that there's folks who are not in that position. There was an article in the paper just the other day about the extraordinary wealth transfer that's about to happen or is happening now based on generational wealth and people coming to the end of their natural lives. And I'm curious if you could talk a little bit about how your clients think about how to make their wealth matter after they've died.
What a wonderful question, because I think everyone has their own way of doing it. Some people view it as, I want to maximize the chance for people in my life to have the greatest springboard possible. If my child is in a job that doesn't want to, or a beneficiary, could be a niece or a nephew, that goes, I'm in this dead-end job and I don't want to do it. All of a sudden I have this infusion of cash. I have the opportunity to go back to school. Some people also go, I have been involved in this charity. I have been involved in this church. I have been involved in this community, and I can't bear to let that community go even after death. I want to provide for it. They make sure that things are set up. Sometimes it's set up in a specific gift, $10,000, more than that, $100. It doesn't matter. Sometimes people come to us with wealth and they go, I want to set up a foundation. I want to make sure that there is a return so that this can perpetuate forever. I'm going to make sure people who are underprivileged or people that come from the same spot as me, that they have the same opportunity that I have. Sometimes they set up trusts that are called charitable trusts that will go on for a certain period of time where they'll receive a little bit of money so they can live, have some income for the rest of their life, but then they'll know at the end of it, everything is going to go to X charity, or I should say charitable entity, because as we are in a church. I think the best thing for you to think about with your estate planning and transfer of generational wealth is, how do I make the world better for people that I know and love, for the community that I know and love, and more importantly, the world. If you can think about that, I think you become a thoughtful and caring and compassionate human, which I always fear that we have little of left in this world. If you can have that in your heart and soul when you're doing this planning, I'll tell you from the bottom of my heart, thank you. So that's a good question. If you have $1 million and you have the beneficiaries identified, is it better to do it with dollars and cents or a percentage?
Things could happen, and that might drop down to 500,000.
Yes. I would say the people who come in that do the specific gifts, they know that at the end of the day, even if the stock market took a huge plunge, they look at the cash that they have in their bank account and they go, no matter what, I can make sure that specific gift of dollars and cents is taken care of. Otherwise, they might include whatever's left over. I've had a lot of people who like to donate to the Humane Society. I want to make sure at least 10% goes to the Humane Society, even if I have just $500 left. I want to make sure there's something that goes there. That's a really good question, though. One more question. Okay. So charitable trusts, the way that they're set up, there's two different kinds, but I'm just going to run through the one that makes the most sense because the other one is a lot of tax nonsense. I'd be happy to talk with you about it another time, but I'm just trying to get for the vast audience. You put money into a trust, and there's a little bit of money that is coming to you, but there's also money that's going to a charity. People tend to use that as, in tax purposes, a charitable write-off. They know that at the end of it, for whatever period, usually it's a period of 10 years, at a times of 10, 20, 30, at the very end of it, everything will terminate, and the remainder of that will go to the charity or charities of their choice. Now, doing a charitable annuity is actually a good question for you to ask your financial advisor. My job as an attorney is to make sure your charitable annuity is at least noticed in your estate planning documents in terms of setting it up and purchasing that. That would be something that a financial advisor would help you with more. And I want to make sure, was there another thing that I missed in there? So supplemental needs trusts, I consider supplemental needs trust to be more along the lines of making sure someone is taken care of who has a disability. So you have stumped me. I have never heard of a charitable supplemental needs trust. So we'll have to talk about this afterwards, and maybe I can figure out where you want to go with that. But I've never heard of a charitable supplemental needs trust. You win.
It's a good note to close on. Avis, you have bested our lawyer in battle. Could we do a round of applause for Chris Kradle, please? Chris, tell us, if people would like to follow up with you tonight or at another time, how could they do that?
So in your binders, or in your folders, I should say, I believe there is a card in the binder. That's going to be my card. You can reach out to me. That is my email, my direct email. That is also the phone line to our main line if you would like to set up. The way we like doing meetings is having you call in. We actually have an intake person who sets up all of our meetings. We would appreciate if you feel comfortable now, in the future, whenever you'd like, you can reach out to us. We're always ready when you're ready.
Thank you so much. Are you available to stick around for just a few minutes
I will stick
tonight?
around for another 15 minutes or so afterwards.
Perfect.
So yes.
Great. Before we wrap up, I want to draw your attention to this handout, which you might have picked up on your way in. I'm handing you mine, Helen. Here you go. Just every session that we've had, we have these takeaway questions, and I keep saying my goal is to spur you to action. So my invitation is to take just the next 60 seconds or so to look at these takeaway questions on the front page. What is your next step in this work? Why is that the right next step? When will you do it? And who can you ask to join you or help you keep moving forward? My challenge is, before you leave here, jot down your answers to those questions, and maybe even put the when in your calendar so that it doesn't get lost in that stack of paper that you probably also have in your dining room table. On the back side of that piece of paper is the information about our session next week. Larry Reynolds and I will be talking about funeral planning. The public service announcement we were thinking of having tonight about planned giving, Dave Carpenter told me when I texted him to ask if he'd like to do that tonight, apparently I said plant giving. Siri problems. Anyway, we had a nice laugh about that. He's going to come and talk about planned giving to Saints Luke and James very briefly next week, but I really appreciate your lead-in to that. The resources listed on the back of this page are specifically for our session next week. So if you'd like to get a jump start on thinking about planning a funeral, what you want to do with your flesh when you don't need it anymore, those are some things you could dig into next week. Chris, we're so glad you joined us, and everybody have a wonderful and safe evening.